I myself am R.BHUSHAN. Welcome to ASG Current Affairs. It is today 28th August 2019. My dear student, don't forget to subscribe, like, share this channel. It's very useful. And basically, this is the editorial of the Hindu newspaper, the editorial of the Hindu newspaper. So, what is the editorial? It's a very important. It has a great significance about the essay writing and many other things. Time to strike the gavel. Time to strike the gavel. The judiciary needs to dispel the perception that is standing as the guardian of the constitutional rights is faltering. The biggest blow to the people of India was delivered by the Supreme Court of India on April 28, 1976. 28 April 1976. 28 April. Five members of the Constitution bench, Chief Justice of India A.N. Ray and Justice H.R. Khanna and M. Hamidullah Beg, Y. Chandrachud and P.N. Bhagwati delivered its judgment in the Additional District Magistrate versus S.S. Shukla, etc. The scarce is inflicted on the Constitution, constitutional morality, constitutional morality, constitutional morality, constitutional morality, and the constitutionalism are deep. Emergency formulation. This was the judgment that allowed the suspension of the writ of the habeas corpus during the emergency. Some of the points made were, in period of public danger of the apprehension, the protective law, which gives every man security and confidence in terms of the tranquility has give way to interest of the state. Enforceability as an attitude of the legal right and the power of the judicial organs of the state to enforce the right or exclusively for the state as the legal instrument of the society, 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 to confer, take away the legally authorized manner justice big personal liberty is but one of the fundamental rights there. Therefore, the suspension of the right to enforce the right conferred by the Article 21 implies the suspension of the right to file a habeas corpus petition to take any other proceeding to enforce the right to personal liberty conferred Article 21. Justice Y.V. Chandrachud, the Constitution, if it is said that even if a person is detained otherwise than in accordance with the law, he shall not be entitled to enforce his right of the personal liberty whilst presidential order Article 359. Presidential order under Article 359 Clause 1 specifying Article 21 is a force. Why have to give effect to it? Justice Bhagwati. This was an anti-constitutional and anti-people decision, but in the true spirit of Rabindranath Tagore words, Justice Khanna held, if they answer not to your call, walk alone. If the answer not to your call, walk alone. This article was basically reducing the way. But Article 21 cannot be the deferred to the people, a sole repository of the people to life, the personal liberty. The right to life and personal liberty is the most precious right of the human beings in civilized society. Justice Khanna said, the case before us raised questions of the utmost importance and gravity, questions which impinge not only upon the scope of the different constitutional provision but have impact also upon the basic values affecting life, liberty, and the rule of the law. What is stake to the rule of law if it could not be the boost of a great English judge that heir of the England is to fall, for a slave to breathe? Cannot be also said that this scared land shall not be suffer an eclipse of the rule of law, and that is the Constitution and Indian laws do not permit life and liberty to the mercy of the absolute power of the executive, or power against which there can be no redress in the courts of law, even if it chooses to act contrary to law in an arbitrary and capricious manner. The question of whether the law is speaking through the authority of the court shall be absolutely significant and rendered mute because of the such threat. Rights in Kashmir. That was during the emergency. Today there is no emergency, yet the constitutional and basic rights of the courts of the suspended in Jammu and Kashmir, worse, the Supreme Court has virtually taken away by their constitutionally remedy to enforce these rights. Regrettably, the court has treated habeas corpus petition in the most casual manner by justifying negotiation of the rule of law. 2. Episodes, though not directly connected, have a law is searching for the answer to functioning of the court. While adjourning of the 2 weeks writ petition challenging the imposition of restrictions in Jammu Kashmir following the abrogation of the Article 370, a bench of the top court on August 12, 2019 merely accepted the pleas of the Attorney General in behalf of the Centre. The fact we have to ensure that law and other situation in Jammu Kashmir is maintained, and that will take a few days to return to normalcy. It further observed the situation is that nobody knows what expectedly happening there. Some time should be bringing normalcy. So this is the most important thing about this is the personal opinion of Mr. Dushyant Dave. Thank you.